Association, Gusau branch, today being the 6th day, slated for the Bar Bench Forum, purpose of which is to strengthen relationship between the bar and the bench, and to interact and resolve hitches, if any, for the smooth administration of justice. Without further delay, we shall now proceed to the opening prayer.
I apologize that I was not able to attend any of your programs. In fact, on Monday, I was supposed to be at the opening ceremony to chair the occasion, but unfortunately, I was away on official engagement. I thought I would come back on Saturday, but I had to stay behind to solve some of the problems there. So I came back on Sunday, and it was very late. We landed around 5 o'clock, so I thought it was not safe for me. So I had to stay in Sokoto, and I came back on Monday. And immediately I came back, I inquired from the chief registrar whether you are still there. And he told me that you have already closed. So I apologize. It was not my own making. It was due to circumstances beyond my control. I actually wanted to be around because I watched the program on YouTube, and it was very lively. And I believe you had a fruitful discussion, so congratulations to you. The issues for discussion, I don't know. They have already raised some of the issues to be discussed. I thought the floor will just be open so that we'll bring out any issue that we feel is affecting the administration of justice in the state and in the country in general. The essence of Bar Bench Forum cannot be overemphasized. It's a forum where both the legal practitioners and members of the bench will discuss some of the issues affecting the administration of justice. It is not a place where we say, well, we blame, this is somebody is at fault or somebody is not doing, but it's a forum where we come out, we should be fair to ourselves, we should be frank, so that we'll bring out all the issues we know that are affecting the administration of justice so that we can move forward. But since you have already raised the issues to be discussed, so I will abide by your own agenda or your own program. The first issue is strengthening relationship between bar and bench. Relationship or cordial relationship between the bar and the bench cannot be overemphasized. But the issue is how can we strengthen that relationship between the bar and the bench? I believe these are the issues that we should discuss so that we will know if the bench or the bar are doing something that is not in accordance with the rule of law or is not in accordance with the let-down procedure. Then we'll discuss it and then come out with a solution on how we can have a better cordial working relationship between the bar and the bench. I want to now allow you to raise this issue so that I can, if you raise any issue that I feel I can respond or I should respond, I will respond to the issue. So the floor is now open. Let me start with the former chairman of the Nigerian Bar Association. Because Galadi, it was during his tenure as the chairman of the Nigerian Bar Association that the Bar Bench Forum, let me say, he rather introduced it because I know during the, I can't remember we started. We had it once, but it was during Galadi that we used to have it at least on quarterly basis. And when his former chairman, the immediate past chairman came in, he also took over from there, and I think we had it only once. We had it only once, due to certain problems beyond our control also. So, Galadi, I commend you. Thank you very much for reintroducing that program. And I hope the present chairman of the Nigerian Bar Association will continue with the program, and on our part, the judiciary, I assure you that whenever the need arises, we will be there dues by the grace of God. So I will start with the former chairman of the Nigerian Bar Association.
I think I have the duty to commend you, my Lord, specifically for your support to the bar. Your support has been yielding fruitful results since my days as the chairman of the bar. You have never relented in giving your support to the bar, which is responsible for all the successes this bar has been recording over the years. Thank you most sincerely, my Lord, and I do hope that you will never relent in giving that support as a mother to the NBA. But like you rightly said, a relationship between the bar and the bench cannot be overemphasized. Because, like I said, when I was the chairman, when this forum was introduced, whatever outcome of the relationship between the bar and the bench, either positive or negative, it is highly unlikely to affect the judge or the lawyer. The end repercussion will affect the litigant. So that is why it is very necessary from time to time we come together, identify our differences and find ways to approach them. But there has been improvement over the years since the start of this forum. Even though there are reports related to minor understandings between judges and lawyers. But the quantum of the reportage, the quantum of the cases has reduced significantly. I think what we need to do now to further strengthen that working relationship is to come up with some certain regulations or practice directions so that whosoever misconducts himself as a lawyer should be reported directly to the relevant authority so that he can be dealt with accordingly. I could remember at a certain visit, specifically to the Honorable Kadi, it was reported that a certain lawyer, without having to mention his name, misconducted himself before a particular judge. So NBA is working assiduously to investigate the issue and take necessary action against the lawyer. But I want to assure you that the situation has improved over years, over the time, and we will try to do our best to see how we can tame the situation from time to time. Thank you so very much, Ronald.
Rules of courts. Because at times, you will see that with apology, an alkali mostly deviates from the necessary let-down procedure to which a lawyer knows it very, very well, and alkali also, or a given magistrate knows it. But at times, it will go off the road, and that will spark the issue in between the lack, the threatening relationship between a judge or bench and bar. So if each and every person or the given alkali or the judge can adhere strictly to the rules of law without any personal interest, I think the issue will be better.
Initially, when I left the official bar and engaged into private practice, I came to realize that there is need for us, we as lawyers, both the private lawyers and the members from the official bar, to understand the court itself, before which we are appearing. Some of us don't understand the court itself, I mean the judge. We have our own individual differences. For you to be a successful lawyer, there's a need for you to understand the type of judge you are appearing before him. That will give you the opportunity to understand him and to know how you are going to present your case logically, so that the judge himself will not be irritated from the way you are making your submission before him. Some judges, they don't like much language. They want you as a lawyer to hit the nail on the head directly, make your point. So if you start making some extraneous submissions before the judge, it will not go down well with the judge and you may have problems with him. So I advise my colleagues that we should understand the judge before we are appearing. Secondly, also, some of us, honestly, we have the habit of going to court in a very bad dress. We are expected as a lawyer to dress properly. Some of us go to court without being colored the normal color shades, with your beef on it, very dirty. So all these are things that we regard as infamous conduct in legal profession. You need not to be expensive in your appearance, but as a lawyer, you need to be neat. Even if you are going to buy, what do you call it? A hen, guanjo, nothing bad. And there's some of us who used to come to court, the accepted and regulated suit you are expected to wear is black and navy blue. But some lawyers wear any kind of dress and come to court. So I advise our colleagues, members of the bar, to observe the rules and also adhere to it. The rules of professional conduct in the legal practice are there. Everybody knows it. And let me come to the bench. Just like what former chairman Galadi said, my lord, whatever is the outcome of every litigation, whether civil or criminal, most especially bail, it ends and bounces back on the person that employed our services. If as a judge, you have problem with a particular lawyer, one way or the other, so it should... Sorry, my lord? A problem with one lawyer in a matter, so you are expected as a good judge to ensure that you have conducted your case justly, judicially and judiciously. Don't look at the problem you have with the counsel himself. Don't refuse bail to a lawyer because you have problem with him, even if the applicant is entitled by the provision of the Constitution and the relevant laws to be admitted to bail. So when this thing is observed, actually I believe it will have good relationship between the bar and the bench. I also enjoin our colleagues, please, if we have problem with any one of the judges, whether a judge of superior court of record of this branch or inferior courts like magistrate, sharia, or even cadis, why can't you approach the judge in his chambers and you resolve the differences between you and him? We used to have misunderstanding among ourselves. So if there is an approach, a good approach between a counsel and a judge, so I believe we are going to understand ourselves so that we will have a very effective administration of justice in Zamfara State. My Lord, generally, I call on you as the Chief Judge of this state to do what you can do for training and retraining of our judges and the magistrate, and to extension to cadis and even Sharia court judges. You are the chairman of the Zamfara State Judicial Service Commission. You are the chief judge of this state. We appreciate the fact that we know you are doing what you can do, and we know there is a lack of funding to the judiciary. But Malam Bahushia Chichikin Kira Akan right. Honestly, there is even in-house training. Just like this bar and bench forum that is going on now. One day, even in a quarter or 6 months or yearly, apart from this bar and bench forum, I think it is very important for you, the Honorable Chief Judge, to organize an in-house training, even between yourselves as judges, between yourself and the magistrates, the cadis, or between lawyers and the judges, so that we will be abreast of the new innovations we are getting in the legal practice in Nigeria. There are a lot of amendments to our Evidence Act and other practice direction and the rules of court that are coming out almost every day. Even in Zamfara State, for example, my Lord, up till today, Sharia Court of Appeal don't have rules. Yes, they don't have rules. Civil procedure rules, I mean. They are on the process of getting one. They invited some of us to help them and make an input to it. So, my Lord, I think all this kind of just needs to be brought so that we will have good and proper administration of justice in Zamfara State. And I'm calling on the chairman of the Nigerian Bar Association, please, whenever you have another opportunity of meeting His Excellency, please emphasize on the need of funding of the Zamfara State Judiciary. We had a law that had been assented by the former government for the financial autonomy of Zamfara State Judiciary, but the law is down. There's need for full autonomy. We know it's a problem affecting almost every state. Only few in Nigeria that gave the judiciary full autonomy financially. Without full autonomy, financial autonomy of judiciary, our courts will not function perfectly. Please don't forget that our divisions sit in Gusau. Sharia Court of Appeal divisions sit in Gusau. Why? The litigants are suffering. Some, they don't even have the money to transport themselves from their localities to Gusau. So there is need for us as lawyers and the judiciary itself to do something about this. So with this very short remark, I rest my case and I wish us successful deliberation, my Lord. Thank you so much.
Allocation. And but as you have said, I'm the chairman of the Judicial Service Commission. I will raise this issue to see how we can come up with a program whereby both the Sharia Court and the High Court will come together and organize a local training for our staff, for our judicial officers, so that we can move forward. You know, with the issue of the autonomy of the judiciary, the law was assented to, I think, July 2022 by the former governor. And even before the governor assented that law, judiciary was not getting anything from the state government, so not to talk of the autonomy of the judiciary. But we thank God, the present governor is of undoing, and he has that political will to assist the judiciary. Like I have said, I think I raised the issue when the Bar Association was inaugurated, the ESCO inaugurated. I informed you that we have started receiving our cash allocation, the monthly cash allocation. And I'm happy to inform you that at present, he has paid all the outstanding allowances for judicial officers in the state. So we are happy with that, and I believe whenever he has said it time without number that he is ready to assist the judiciary. So I believe whenever we approach him with any problem, of practice direction. Well, I believe we have legal practitioners disciplinary committee, and the rules are there, the guidelines are there. Whenever a lawyer misconducts himself, the best thing, don't fight him, the best thing is you just write to the Bar Association. You start with the local bar. You just write to the Bar Association and put up your complaint. And I'm sure they are ready to investigate. And if the need arises, they will forward it to the national body of the Bar Association. So we don't need any practice direction here. The law is already, or the rules are already there. Legal practitioners disciplinary committee is there. I worked for that committee for 10 years. From 2006 to 2016. So I know how they operate. Whenever you have any complaint, so let me just call on my colleagues, the High Court judges. Although the Qadis or Sharia Court of Appeal is not represented here, they are not here. Whenever you have a problem with any lawyer, just listen to him. Let him say whatever he wants to say, and you record. If you feel what he did is not in accordance with the law or in accordance with the rules of court, give your own decision. If you feel, well, he has misconducted himself, write your complaint to the Nigerian Bar Association. Don't take him in open court, please. Improper adherence to rules of courts. Rules of court. But my advice to lawyers is that if you observe that a judge, a magistrate, a Qadi, or a judge of the High Court is not, the court, make your submission. Let him record. If you are not satisfied with the decision or the action he has taken, the best thing is for you to appeal. We are all, even the High Court is the court of first instance. We have the court of... So if you feel the judge is not conducting himself in accordance with the rules of court, and you try as much as possible to make him understand that he's not conducting himself in accordance with the rules of court, and he did not, take your advice. So the best thing is listen to him when he gives his decision. If you are not satisfied with the decision, you appeal to the next court. That is my own response in respect of this issue. Then, problem you have with the lawyer, you can take up that issue later. Like I have said, with the Nigerian Bar Association, you can write your complaint to the association and point out what you feel the lawyer did in the case, which you feel is not in accordance with our rules of court, or not in accordance with the rules of professional conduct in legal profession. So please, my colleagues, don't ever judge a case based on your relationship with a particular lawyer, whether you have problem with him or you do not have problem with him. Just conduct your case in accordance with the rules of court, in accordance with the Constitution. We have already, all of us have taken an oath that we will conduct our cases in accordance with the rules of court, in accordance with the constitutional provision without fear or favor, affection or ill will. Though that should be a guide to all of us. If you have anything in respect of the issues that have been raised, although you came in late while we were discussing.
My learned brothers, the Honorable Attorney General of the State, members of the bar, ladies and gentlemen, good morning. I should start by tendering apology. In fact, I've been in the High Court premises for some while ago. I had to put in some issues because I told some of the council that told me that I will deliver some judgments while this workshop is going on, which we said, oh, we agree we'll meet. On the issue of which I met being discussed, I think relationship between a judge and a counsel ought not to affect the case before the court, like has rightly been pointed by His Lordship, the Honorable the Chief Judge of our state. We as human beings, in one way or another, at one point or another, there could be some discrepancies, misunderstanding, which ought not to have come, but as human beings, it may come. So my view is that that should not affect the facts of the case, because as judges we know we are bound by the oath of oath which we took to be fair, to deal with their case fairly, without fear or favor, affection or ill will. And like has been said by His Lordship, anything that counts, it will affect the litigants directly, which they are not involved in that so-called misunderstanding. So my view, tally with that of the Honorable CJ, conduct your case. If you have anything to settle, which you feel a judge did not do correctly, maybe mutually discuss the issue with the affected judge or magistrate. If he refuses to see reason in what you say, you can climb the ladder and raise it up with the Honorable the Chief Judge. I believe if the Chief Judge invites His Lordship or the magistrate concerned, it is my view that the issue will be put to rest, so that working amicably will continue. Because it is bound to happen. There is a proverb saying in Hausa which says that even between the tongue and the teeth, there could be some problems sometimes. So that's natural. But we here on the other side, I advise myself and others that we should be, as much as possible, try to ensure that we chew whatever we sow and we swallow it without even allowing it to be seen by others.
Sometimes it's not chewable. Sometimes it's not chewable.
If then, as human beings, we cannot be able to do that, then you can show your dismay and what have you, but in a polite manner, so that issues are not joined. Because if the issues are joined, especially in the open court, a lot of things can come. So in order to avoid that, we should be guided by the principles of the ethics of the profession, and even more so what the public would see as displayed before them. This is my little contribution.
Thank you. The relationship between the bar and the bench for the betterment of the legal profession. Now, at this level, at this juncture, I think it would be pertinent for us to know that this profession is called learned because there is nothing personal in it. You are discharging a professional duty. That is why, if you remember professional ethics, they said you have a duty to yourself, duty to the court, and duty to the opposite counsel. If I may recall, one of the benchers that taught us at the SAN induction, he said, if you disagree with a judge, you don't have to be rude. Rather, you just pray the court, my Lord, can we have a ruling on this? If you have a ruling and you feel you are dissatisfied, that is why the appellate courts are there. You proceed to the court of appeal rather than staying behind and using the media, which I so much detest. If you observe, I hardly talk to the press, except when there is a very, very critical issue that the opposition may taint. That is the only reason why I will talk to clarify issues. Now, when you know that you have another avenue to ventilate your claim, I see no reason why you should stay behind and be, blabbering over the attitude of the judge or the conduct of the court in respect of your case. I think it is highly and detestable and unprofessional to hear a counsel blastering a judge over a case. To me, that is the peak of disrespect. And what is more damning is, whenever you want to do something, you should always put at the back of your mind the place where you came from. Now, and I'm not saying I'm castigating other regions. I've been to other regions for a matter. I've seen how they talk to a judge as if they are the controllers of the proceeding. A judge will say one, he will say five, and he will say it in such a way that you, by the impression, this person is rude. I can remember an incident with Honorable Justice Jega of blessed memory. I don't want to mention the name of the council. If he says one, the council will say 10. The judge is trying to interject, will be trying to interject to control him. Say, my lord, I insist. So Jega now said, okay, finish your submission. After the submission, he said, we are delivering the ruling now at the Court of Appeal. It took them about roughly 20 minutes. Then they said, counsel, stand up. This is the ruling of the court. They delivered a ruling against him, striking out the application. Now, if you weigh this, who do you think is at a loss? It's him. Him that is going further.
Is the litigant.
So it's the litigant and the lawyer. So, if you look at the way they did the ruling, it was so castigative, so disgraceful that even the lawyer was like he was sick. He didn't think it would be that way. So I will urge my fellow colleagues, though I have put my own timetable to start appearing before my lords by January, but
I hope so.
So far so good. My lord, I was. It was a timetable I did. Then on the issue of what I saw in the, I don't know whether it is discussed, but I'm sure it was discussed on necessary delay of case.
No, we are on first item.
Okay, you are on first item. Okay, my lord. So, with this little journalism as the first yardstick, and on the issue I had my lord talking on dressing, I assure you, that one is a sure banker. The lawyers from the ministry, on my own part, will be a distinctive.
You start giving them. Start giving them wardrobe allowances.
Respectfully.
So I'm applying on behalf of the generals. We should start giving them wardrobe allowances.
In addition to what she said, in addition to what my lord said, I have contacted those people that used to wardrobe us when I was in Abuja to also extend their warming hands to Gusau. By God's grace, you are going to see changes. I'm grateful, sir.
We hope so. I'm
grateful, sir. Thank you. This is by the Commissioner for Finance. Yes, that he will disburse that fund. He assured me. Yes, my lord. Thank you.
Yes, just
any of the...
It is definitely true that whoever is going to take much of the blame maybe will be the lawyer himself, because he has taken, it is his duty to protect the interest of his client at whatever cost. So in a situation whereby a lawyer will come to court unprepared, with a mindset of only seeking for adjournment, or in another issue, he will just write a letter to the court saying that he is seeking for adjournment without any cogent reason. Without any cogent reason, he will do it again and again. It will even be more precarious when maybe he doesn't have a good case, so he will use that opportunity of seeking for adjournment so that he will be foreclosed by the court, and he will transfer the blame, the whole blame to the court. Like, okay, look at what the court has done. It has struck out the matter, this and that. So you can pinpoint out some lawyers you know that they can seek for about 7 adjournments or even more before the second issue. So like what Galati has said, that there is a need.
It's on the second issue.
The issue of relationship, instead of for the judge to always swallow what the lawyer will say, let us find an amicable situation whereby the lawyer will not use the opportunity that because the bench will not descend on the arena, and he will start pushing out whatever he wanted to say to the court, and the court should have to swallow it. I am very emphatic about this issue of adjournment. That is my only concern. If you have a cogent reason for adjournment, you can seek for adjournment. But if you don't have a reason for seeking for adjournment, please don't do it. Time is very precious. It's precious for you, and it's precious for the court also. It has so many things in the course list. You can have a course list of about 10-15 cases, but hardly can you find 2 cases going on. Almost all the others are either seeking for adjournment by a letter written beforehand, or seeking for adjournment there and then, because the lawyer has nothing to offer because of lackadaisical attitude. So that is my concern really.
Thank you, my lord.
To meet with His Excellency, we should do whatever that needs to be done to intimate him on the need for independence of judiciary, funding and other things. My lord, I really wanted not to discuss about this issue till when I personally meet with my lord and inform her of what transpired at our last meeting with His Excellency. And I will not, I will stand by that. The only thing I maybe want to see out of that is we truly observe his passion for judicial reform. I spoke for 21 minutes. He responded in 27 minutes. Out of the 27 minutes, 13 minutes was on the issue of judiciary, how he wants judiciary to be reformed, what plans he has for judiciary, and we agreed together that time, and even when we later met with the SSG, that we are going to sit together and see how what things need to be done by the grace of God to make sure that judiciary is independent, and we are going to work together by the grace of God very soon. He assured us next 2 weeks we are meeting again, and by the grace of God we will meet to discuss that. Thank you so much. At appropriate time, people will know the discussion.
And you are all aware, he came here, he inspected the courts, we went to Sharia Court of Appeal, he inspected the place, and he sent his team to come and see how they will, renovate or remodel the courtrooms, the chambers, and all other gadgets on information technologies. They said we should provide them with the necessary information on what we require. And I've already got the checklist from the Nigerian Judicial Council, which I've already submitted to the team. And I believe they are working on it. So when the time comes, I believe you will all see the result, the positive result, by the grace of God. The floor is now open. Members of the bar and other, let me see, I can see some guests here. If you have anything to say with regard to the issue of strengthening the relationship between bar and the bench. So the floor is open. If anyone has anything to say or to ask, just raise your hand. They will give you the microphone and you ask your question.
All the noble justices around, please permit me to go on the existing protocol. My Lord, on this topic, or this issue of the relationship between the bar and the bench, I will say that I really appreciate the members of the high bench and the lower bench in this jurisdiction. The relationship has been very cordial compared to other jurisdictions. I have witnessed in previous years when a judge will tell a private lawyer that in the presence of litigants, I will send you to the prison. That has never been the case in this jurisdiction now. All the judges, I believe they have respect for private lawyers, and we really enjoy that relationship. On the issue of other issue, I believe the relationship will further strengthen if our judges will accommodate our younger ones, our juniors, because some of them will come and say, the judge was not accommodating to me. I could remember when I was a young lawyer, where I started my practice when the Honorable Justice Jafar Mikalu was the presiding justice in the Zuru Judicial Division of blessed memory. He was always very polite. When you are making any submission and you discover that it is not proper, he will guide you. So we enjoy my laws, especially our juniors, to guide them, accommodate them, be patient with them. That's the only way they will learn. Because some of them will run, when you send them, go to social courts, they will say, no, I will not go. So we are pleading on behalf of our junior that my Lord should please accommodate them and be polite to them, guide them, so that they will learn more and then become more competent. On the issue of the adjournment that we normally seek, it is true. I am a witness to that. I've seen some of my colleagues writing to the court that they are not well, or they have traveled out of jurisdiction. And by the time you finish from that particular court, you meet them in another court within the jurisdiction here. So it is that with that, there's no way there will be a cordial relationship between the judge and the bar. So I advise us that we should try to guide against that. The other issue, I also want to stress the point that in the appointment of judges, especially the Sharia court judges, there should be a serious consideration, because most of them, they don't even know what it takes to be a judge, or what the duty of a judge is. I had a cause at one time. I appeared before a judge at the Sharia court in Gwagwada. We were doing the case, and he said, within this week, I'm going to finish this case. I just laughed, because at the point he had to confess that he never had any training. He is not aware about the Constitution. He doesn't even know anything about the criminal administration of criminal justice. So there is a need to really find a way of before the appointment of scrutinizing those that are to be appointed. Also, my Lord, it is also another way where there will be no good relationship between the bar and the bench if we as lawyers will not be polite to the judges. I still remember the advice of one of my lecturers of blessed memory, Baba Shani of the ADU. He said, even if it is your own son that is on that bench, even if it is you that appointed that boy that you consider a boy on that bench, you will respect him, otherwise you will be embarrassed. And before you get out of the embarrass, it is another issue. So it is good that for a good relationship between us and the bench, to respect whoever you find on the bench, have a good respect, and then you also will get the respect. The other issue again is that of the issue of the corruption. This is largely happening at the Sharia court level. Because of the corruption, you will make a submission that, look, you don't have jurisdiction. You will cite High Court judgment, you will cite Court of Appeal judgment, you will cite Supreme Court judgment. They will close their eyes to it and give their own ruling and say, I have jurisdiction. The consequence of this is that a lawyer now, or the litigant, will now have to provide, when you are going on appeal, you have that to be an extra cost, extra time wasting and suffering to litigants and even to the lawyers. Even if we are asking for maybe something to prepare the appeal and prosecute the appeal, it is to have so many other things to do, and that will not in relationship. I have cause to meet the Grand Cadi on this occasion, on this issue. I have severally spoken to him, but wherever you go, it is still the same. So, my Lord, the Honorable Chief Judge, I think you help us in this area. I think this is much I have to say for now. I thank.
Between the bar and the bench is concerned, I think one issue is also vital. The need for the judges to take control of their courts. When I was a young lawyer, I used to have it very difficult to appear before you because of the way you have absolute control of your court. But as I aged in the bar, I came to realize that that is very, very important for every judge. I have seen judges who are not like you, their courts, appear to be a bit loose. You see lawyers talking in the course of proceeding, which is very, very unbecoming of lawyers. Sometimes they argue, sometimes they talk, sometimes they discuss unnecessary issues during proceeding. There are few of the judges, sometimes, my Lord, take necessary measures to stop that from happening. Some condone it. So I think it's necessary to begin to, advocate that while it is not too good to be too harsh, it is also important to take charge and control of your court as a judge. But it is also necessary that we try as much as possible to desist as lawyers from talking to judges regarding our cases privately. If you have a case before a judge, do as much as you can not to discuss your case with him. I have that in me over the years that I have never discussed my case with any judge. I think that is also necessary. We should try as much as possible not to discuss our cases, not to use our personal relationship with the judge to discuss a case with him. My Lord, when a lawyer has any issue with a judge, I think what he should do, if that judge has some reasonable degree of understanding, it will not be out of place for the lawyer to meet the judge and discuss with him. I don't subscribe to the issue of writing. I personally don't subscribe to the issue of writing. but I'm more comfortable to talk to the judge personally. If, as a lawyer, you don't have certainty on the judge, I think the best thing is to take him up to the superior. Okay, my lord, to take him up to his superior without having to write formally against him. But another important thing is choice of words. Some of us are rude, even in their usual dealings with their colleagues. So we need to understand the language. We need to understand the language that you should apply while talking to a judge, and vice versa. As ministers in the Temple of Justice, while in court, we are trying to protect and defend our clients. The judge also has the duty to talk respectfully to the lawyer as well. So it's vice versa. We need to respect you while talking to you. You need to also respect us while addressing us. I have issues regarding adjournment, but I will have to adjourn it until unnecessary delay. When we come to unnecessary,
if you want to discuss any issue, the best thing is for the two sides to come together and meet the lawyer and discuss, and the judge and discuss. But I don't buy that idea of discussing the issue with a lawyer or a judge. On the other issue of judicial officers to take control of their courts, yes, I remember. Let me just give you one experience I had in 2003. When I was in Maiduguri, I was the chairman of the Election Petition Tribunal in respect of the governorship election, Alimadu Sharif also. So all the lawyers that were appearing in that case were senior advocates. Awomolo was on the other side, Yusuf Ali was on the other side. So they were just, in open court, they were making noise, they were they really wanted to fight. I said, okay, senior advocates, when you finish your quarrel, please, you let me know so that we'll continue. Awomolo then said, he started calling me a baby judge. Wow. He said, this is a baby judge controlling the court. I said, okay, you see a baby judge. So I allowed him to say whatever he wanted to say. And at the end of the day, I gave judgment against him. Not because he said so many things in open court against me, but because they did not prove their case. And so we are going upstairs, we are taking this. So I said, oh, go to wherever you want to go. I didn't want you to go there because I want to learn. They went to Court of Appeal. Court of Appeal affirmed my decision. They went to Supreme Court. Supreme Court affirmed that decision. So when we met at the body of benches meeting, he was like, my lord. I said, oh, Lana, they say, and you remember when you are calling me a baby judge? He said, no, my lord, I did not say so. I did not say so. No, my lord, I was just joking. I said, okay, it's all over. So you have to take charge of your own court. You just let the lawyer say whatever he wants to say. Record what, but conduct your case in accordance with the law. Don't say because you have a lawyer try to abuse you in open court or to argue with you, you will decide a case and then give a decision against him. No. Please listen to him, read the facts of the case, apply the law to the facts of the case, and come up with a just decision. Okay. Somebody raised his hand before you. No, there's somebody sitting at the back. Is that Nasuru? Okay.
Present, the learned Attorney General of the State, my learned colleagues and other participants here present, good morning, Assalamu alaikum. And my lord, the issue I wanted to talk about is the delay in administration of justice.
It's the next topic.
Strengthening relationship between the bar and the bench. I think it is important for the bar and the bench, members of the bar and the bench, to understand each other in terms of their behavior, how some of us are naturally made to be hot-tempered, others are cold. Some of us can be very, very aggressive at the slightest digression from a particular rule or procedure. So you will see the reaction coming from a lawyer. Because as a judge, you are sitting to decide a dispute between party A and party B. This party A and party B, each of them is expecting the judge to, even sometimes when some of these parties know fully well that they don't have a good case, they will be expecting your lordship to deliver judgment in their favor. Lawyers will sit in their office, receive briefs from their clients. Sometimes, when the judge says this, you say, no, you won't even know, my lord, that he was talking to your lordship. So until somebody says, calm down, you will now come to your senses. Yes, you are appearing before you. So this issue of understanding the psychology of the judge, the counsel as well, and tolerance. Sometimes you have to excuse some of the counsel appearing before you. So also the counsel will understand that yes, the pressure on you is very high, because my lord will always be cautious. What do I say? Where do I go? So that this one will not suspect me, because you can never escape from that. This one, this one will be saying, will my lord do justice the way she was talking to me today? So these are some of the issues. By the time we understand ourselves in this way, this man, naturally made to be aggressive, I know how to handle him. Talk, calm down. I'll make you to calm down. The other one is called, I know him naturally. I think once we have these factors at the forefront, by the time we sit to decide cases, they will definitely help in strengthening the relationship. But once this thing is absent, my lord, I think anything is bound to happen. And then lastly, let me say, whoever is coming to court with the belief that he will not get justice, my lord, anytime he appears before you, when you study his demeanor, you will understand that he is behaving contrary to the rules of the ethics of the profession. He will never be friendly to your lordship, because he had formed that belief that he is not going to get justice. So in that situation, my lord, I think there is need to also understand and study the counsel appearing before your lordship. This, I believe, will help in strengthening the relationship between the bench and some members of the legal. Thank you.
It's low-week activities. I want to appeal to your lordship to maybe henceforth take the responsibility of organizing bar bench forum at the judicial JSC level, so that at JSC level, yeah, so that it will be compulsory for all. No, I didn't mean the venue, my lord. I mean the sponsorship of the program to be sponsored. The program should be sponsored by JSC. Yeah, to be organized by JSC. Being you the chair, my lord, it can be compulsory upon all of us to attend, instead of
one, an attitude, let me put it this way, of the judges of my lord and in condoning or overlooking improper dressing of counsel before the courts. Many times, if I appear before the court or with any other person around, you can see a counsel addressing the court without properly dressed, and the judge overlooking in this very state, I can see. I raise this issue because any time I found myself outside the state, I can remember I was embarrassed by Mr. Justice Echo, simply because I feel like something scratched my head, just to reduce my week. But he was shouting on me. Not until when SEN understand and make guess for me. So my God, he was answering you that he felt something he said. That was why he was scratching his head. But he was shouting on me, why are you trying to make me? Where do you come from? What? But in this very court, the council will address the court without him without even the proper beef before the court, and the court will look at it or and this is now, at the end of the day, it will not harm you until when you get outside this situation. My Lord, secondly, the respect for the, I think strengthening relationship can be strengthened between once we respect one another. We have to respect the court itself. In fact, we are bound to respect it, but going by the rules of the court itself, rules of professional conduct, and the like. We are bound, any counsel before the court is bound to respect the court and its rules of procedure. At the same time, the court is expected also to have respect for the counsel, as we have normally. Why I'm saying this, my Lord, we always expect, we will be happy to come to court. Sometimes, my Lord, so it's not until when it is 10 o'clock, before the judge will say, my Lord, the court will not sit until some time. My Lord, I am appealing out of understanding, respect, my Lord, to have this properly understood, my Lord.
I don't know whether I will apologize for our comment or not. Yes, because the information given to us, the occasion will start by 10. So, the information.
Yes?
Yes. So that's why I just prepared to leave Chirabu by.
So what time is it? What time did you come in?
Yes. I came here 10 minutes prepared.
Okay.
So it means I have 10 minutes before the time.
What? Who gave you the Who gave you the time of 12 o'clock? So no, I just want to ask you, who gave you that time?
In cases they prosecute, we also have members of the bar, that is the private bar, who defend accused persons, who file civil cases in respect of their clients, or defend them in civil matters. So we all have a very vital role to play in administration of justice, and each one of us that is not working in accordance with the provisions of the law, in accordance with the rules of court, in accordance with the professional rules of professional conduct, will cause unnecessary delay in administration of justice. Some of the factors, I believe, that cause unnecessary delay of cases, like the issue raised by my learned brother, Justice Bello Kucheri, unnecessary application for adjournment. Sometimes you'll find that a lawyer will write to the court seeking for an adjournment of a matter that is before so court. There's sometimes some occasions whereby the opposite counsel will tell the court, my lord, I saw him there. He is within the premises. He's not outside. Sometimes a lawyer will write, will not give any reason why he is asking for an adjournment. Sometimes a lawyer will tell you, like in my own case, they will tell me before the Federal High Court. I always tell them, well, Federal High Court, my court, I believe, as the chief judge of the state, my court take precedence. So you can't tell me that you have a case before a Federal High Court, you cannot come to my court. I will not grant that application. These are some of the issues that mostly cause unnecessary, delay in administration of justice generally. Also, the issue raised while we were discussing strengthening relationship between the bar and the bench, lack of adherence to the rules of court, also, I believe, caused delay in administration of justice. In a situation whereby a judge or a Sharia court judge or a magistrate does not adhere strictly to the rules of court, and a counsel will now start making arguments, and the lawyer or the judge or the magistrate will go ahead and ignore, what the lawyer will say. Of course, like I have said earlier on, well, listen, go ahead with your submission. At the end of the day, he will give his ruling or judgment, and then you will appeal. But that is also causing a lot of delay in administration of justice, because if you adhere strictly to the rules of court, you will conduct your case, give your judgment and ruling in accordance with the provision of the law, rather than causing unnecessary, expenses to the litigant and the lawyer. Because at the end of the day, if you don't adhere strictly to the rules of court, he will appeal, and you will find the case will now be sent back to the same court or to the head of court for assignment to another judge for retrial. So that has caused unnecessary delay in the administration of justice also. I believe there are so many issues that are causing delay in the administration of justice, which I will allow members of the high table to discuss, and members of the bar and other, participants that are here. We can see the Sharia court judges just came in, and the Qadi Hamza was trying to explain why they came late, that they were informed that they had to be here by 12 o'clock. And I have already pointed out to him that the time on the card is 10 o'clock, so maybe they did not.
Issues causing delay, generally, they come from the bar and from the bench. Some of us, for example, on this side, like not sitting as at when due. Like everybody knows, His Lordship, the Chief Judge, stick to time. Speaking for myself, I do not always. And some of the council, you find frivolous applications coming sometimes. On my own part, I do condone some part of it. And at times when I speak, some of the council may bear me witness. I used to be very harsh and very rude after having advised severally. So therefore, in order to put an end to this issue, we should all do what is needful. Everyone knows what is needful of him to ensure that smooth running of cases, is conducted. Court sitting as a well-do, unless when there is a reason for that, and you give notice to counsel so that they know that the predicament coming their way, so that if they have some other thing, they can go and attend to them. But the counsel should please stop giving frivolous excuses. Like, for example, I had several occasions where even a senior counsel came to the court. The other counsel is not even in court. He was given a reason for the absence of that other counsel because he wants an adjournment. So you find that it's like kind of a collaborative whatever between them. This I will have to say. Thank you.
Okay, thank you. I wanted, it was deliberate that I did not raise this issue of court last sitting on time. I wanted the members of the bar to raise the issues themselves, because I know it will be one of the issues they will raise, so that we can discuss it thoroughly here. Any of the High Court judges that want to say something on the stage?
procedure rules, for example, why you can control your court. The pre-trial conference. It is very important. We have to use it. In pre-trial conference, you can name the number of applications a lawyer can make during the trial, during the proceeding of the proceeding. You can name the number of the time to be given to him for making his cross-examination or the chief examination or whatever. You can even name the number of adjournments he will seek. The number of adjournments he will seek. You have to pick it out. So it's like now we have done this issue of pre-trial conference. It's even more a blessing. It is even adding to the clock of procedures in the High Court civil procedure instead of us to utilize it more. So that if you know the number of adjournments, you cannot go out and start making grudges that you have made an application for an adjournment but it was not granted you. If you don't have to make to see. I don't know why. Maybe I am just very particular about this issue of adjournment. A lawyer should help the trial to be very speedy. So instead, in a situation whereby it is the lawyer himself who is causing the delay by seeking an unnecessary adjournment, like I've said before, then I think the lawyer is not doing his duty. So we should try and make use of this pre-trial conference to take out the number of adjournment we should give to a particular lawyer, and the number of applications he will make, and so many other things should be streamlined there in the pre-trial conference. That is my view.
Thank you. One day, my Lord,
he must give reason why he was not able to file the necessary documents or to conduct the pre-trial conference within the 45 days as specified by the rules of court. If we adhere strictly to the rules of our court, I believe all this delay will be minimized. In civil matters, of course, I don't think there's any problem in civil cases, because most of the time, of course, the plaintiff will not come to court or the lawyer for the plaintiff is not in court. Of course, I will look at the provisions of the rules of our court and apply the provisions of the rules of court. If it demands striking out the matter, I will strike out the matter. Let him come back to court and tell the court why he was not in court, why he did not comply with the rules of court. If it is a situation whereby the rules of the provision of the law, just like in pre-trial conference, say if the plaintiff is not in court during the pre-trial conference or he did not conduct himself, you just apply the rules of court and give judgment against the plaintiff. So we have to adhere to the rules of court so that all this delay in the administration of justice or delay in, handling the cases will be minimized. And if we do that, I believe both the lawyers and the litigants will be happy with the court. Thank you. Anybody? Okay.
Well, respectfully, my lord,
sai ka bi wannan ka'idar. In mutum ya zo kotu bai bi wannan ka'ida ba, sai ka yi amfani da abin da doka ta ce. Sai ka yanke hukunci nan take. Na san kila ko cikin, I'm not very conversant with the procedure at Sharia court, but I believe Sharia court ma na san kuna da wannan provision din, wanda in mai kara bai zo ba ga abin da doka ta ce kai, in mai kara ya zo bai bi ka'ida ba ga abin da doka ta ce kai. To abin da nake cewa kowa ya bi wannan ka'ida. In aka bi wannan ka'idan da doka ta ce, insha Allah duk waɗannan matsaloli da ake samu na rashin kare shari'a cikin lokaci za mu yi maganin su. In brief, abin da nace kenan.
Central filing. I'm not central filing at the central registry. So you have to file your processes there and the processes has to follow administrative journey before it reaches its final destination, which is your office yourself. And at times you find out that you may not be available, you may be out of the state for other engagement, and nobody is there to assign the case to another judge. I think it's better to appoint someone in this case. Secondly, we have other issues in criminal cases. Unlike civil cases, the rules are very much clear as to the time, date, and how to go about the case. But in criminal cases, more especially in bail application, you find out a cell counsel will be served with hearing notice, maybe giving her like 2 weeks, but he will serve you with counter affidavit on the date of hearing, and that counter affidavit carries a lot of weight. It will be attached with some exhibit, and in that situation, you have no any alternative than to ask for an adjournment. Then lastly, the issue of funding. Like what we experienced in the past 4 to 5 months, you find that the judiciary has not enough fund, to go about their day-to-day activities. You find your process, the process will be done at the central registry for over 2 to 3 months. Thank you so much.
Cases ɗin ba. So abun da na yi bayani cewa in dai tafiya doguwar tafiya ce, na ba da misali kamar zuwa aikin hajji ko kuma na san zan ɗan daɗe. Ina ba da instruction ga su litigation department ko chief registrar in an kawo cases ku kai ga number 2 sai assigning cases in ga sauran judges. Sai kuma batun shi wannan delay da ake samu ga wajen cases ya yi wajen abun ganshi contribution din shi ya ce kaman ga civil cases ba matsala amma criminal matters na adda matsala. So abun da na ce mashi ko criminal matters babu matsala, ya danganta daga alkali ko kotu. Criminal matters prosecution an ba su lokaci su kawo shaiduddukansu, lokaci ya ka ba su adjournment 1, 2, 3 ka daga ba su kawo shaidu ba. So abinda nake ni cewa na baka dagawa karshe, in baka kawo shaidunka wannan lokaci ba, kotu will take the necessary action in respect of the case. So in lokacin yayi ka zo baka kawo ba, zan ce na rufe case in prosecution. But that has to be on record cewa ka ba su wannan damar, kuma record ɗinka zai nuna cewa ka zo ka yi ta ɗagawa ne, ka yi ta ɗagawa sun ƙi kawowa. Ba wai kila ka zo kotu ba the court clerk ya zo ya ce maka, well, prosecution said they do not have any witnesses in court, sai ka ce a ɗaga case. Kaga record ɗinka bai nuna ba, amma ka shigo kotu ka kira case, prosecution ina suke an ce ba su nan, then you take a decision. Ko kuma ya zo ya ce a bai da shaidu, wannan duk sai ka sashi kayan recording cewa to rana kaza mun zauna mai gabatar da ƙara bai kawo shaidu ba, mai gabatar da ƙara ce baya da shaidu. Kaga do record ko appeal an ka tai, record ɗinka zai nuna cewa ga abun da ya faru a cikin kotu, amma kila baka zauna a kotun ba, iyaka dai prosecution court clerk ya zo ya ce maka prosecution sun ce ba su da shaidu, ka ce a daga. Kaga ba wani abun da ita ko da an ta appeal, court of appeal za ta duba ta gani cewa ai lalle ko ka zauna ranan amma prosecution ne abu suka. Amma in record ɗinka ya nuna duk abun da aka yi gashi ka rubuta a rubuce, ba lahin ka bane, ba lahin kotu na, ba lahin masu gabatar da ƙara ba su kawo shaidu ba, kuma ka ba su lokaci ba su kawo shaidu ba. So kaga wannan kai kana da ka kare kanka, ka kare kotu, ba lahin kotu na ba lahin su ne. Sai kai taking decision abinda doka ta ce kai. In ba su da shaidu shikenan ka sallami accuse. In kuma su abun nan ne sun fara kawo shaidu, to ka closing case din prosecution sai ka ba defense dama su kuma su zo su yi defending din kansu. Dama abun da nace briefly kenan a abun nan Hausa.
A lokacin da ya magana kan rules na haya court wanda suke mu alƙalamu muna da musu wanda ke amfani da su, shi ne shari'a court civil procedure rules 2018 wanda suke na imanin kowa ya kwafi, kuma kowace chamber na wasu ne a apply da shi da suka fito an ba shi kwafi, kuma ɗaya ne don a sauƙaƙa ma al'umma, wanda kamar yadda ya faɗa shi karanta cewa a rozar Najeriya babu irin cikin yanzu, kamar yadda Center for Legal Services ta tabbatar a Zaria. So ya kamata a yi shi. Na biyu ba ya kamata wajibi ne a yi shi. Kuma na biyu shine practice action wanda ake 2021 daga 1 day zuwa up to 3 months kowane case an faɗi large wanda ya kamata ya zama wanda idan ya wuce shi alƙali in a yi complaint za a yi duba in ya yadda gangane za a yi hukunta shi haka ma lawyers an yi magana a kan ko ma ciyar ya san kokarin da ya ba contribution baya akan wani ga barista Sadiq ya san abin da ya yi akan wani kuma har yanzu kamar yadda faɗa shi ba wanda ya yi complaint cewa ga wata doka wadda abin daidai kamar yadda wannan tsari yasa saboda haka kamar yadda Mado ta faɗa ya kamata duk alƙali ko wani lauya da ya bayyana idan bai bi ƙa'ida kai zai go ahead ya bi abin da doka ta ce ya yanke hukuncinsa cikin wannan mun abu cewa lauya yana da ɓalle tu a jome bayan tu a jome idan har ya ƙara wani lokaci da gangan ba reason alƙali zai ci gaba yanke hukunci kamar yadda doka ta faɗa da haka kuma yadda ita shugaban ta faɗa ba makawa sai an bi wa'annan ayyuka da dokoki sannan aiki zai yi idan mun bi za mu zauna lafiya amma duk sanda mun karkace mun ido mun kasa son zuciya to babu shakka za mu zama cikin wahala muna fata Allah shi tabbake mu dora mu kuma assalamu alaikum
to ai kun ga abu duk ya sauƙaƙa yadda a jomen biyu ka ba suwa in babu wani dalili sai kai amfani da wannan doka ka yanke hukunci shikenan sannan kuma nan ina so in ƙara jawo hankalinku wannan ba bench forum ba wai an zo ne don a ce laihin wane ne ana kawo bayanai ne yadda lauyoyi suka san abubuwa na faruwa yadda mu masu shari'a muka san abubuwa na faruwa don a ga ya za a shawo matsala kan matsalar a samu daidaituwa saboda aikinmu ya yi kyau. Like I have said da ba kunan wannan gwamnati tana kokari kuma ku dukan ku kun sani recent alƙalai sun sani duk wanda yake ma'aikatar shari'a ya sani gwamnatin nan ta yi iyaka kokarinta kuma tana bisa iyaka kokarinta kuma an yi alƙawalin da duk wasu abubuwan da suka shafi judiciary za a saboda haka mu ma ya kamata mu tsaya mu yi aikin mu yanda ya kamata saboda in kun tuna ko ranar da shi although Kadis ne da judges lokacin shi his excellency da ya zagaya a kotunan nan ya ce zai iyaka kokarin shi kuma mu saura ya bar mu da Allah ko mu yi aikin mu yanda Allah ya ce mu yi in kuma ba mu yi ba mun san abin da annan in nan duniya ba a yi mana hukunci ba za mu je mu iske abin mu can saboda haka ya kamata kowa this one should be at the back of each and every one of us ya san cewa
nan zaune zai su ce sai ka ba da 5,000 2,000 nawa sannan a yi maka aikin su baka kwafi to abinda na sani ni dai abinda doka ta ce in aka yi jajinin kowa na da yancin ya nemi a bashi kwafi na jajinin sannan na san doka ta yi specifying fees din da ya kamata ka biya ko to wannan fees din kawai ya kamata ka biya nan abinda doka ta ce ka biya amma ba wani ya zauna maka cikin kotu ya zo ya zaune ya ce to ka biya ne kaza zan maka takin ba ko in maka producing record of proceeding ka bi abinda doka ta ce ka yi ka je ka yi applying to court yadda doka ta ce an gama shari'a ina son copy nan za a faɗa maka an producing okay nan ga copy din saboda amfanin biyan fees din ka san in ka ce wani wuri akwai inda ake magana public document and so on and so forth za a ce sai ka biya ka nuna cewa ka biya kuɗi kayan ne sai amfanin biyan kuɗin amma biyan kuɗin kuma na waɗanda abin da doka ta ce ka biya kana ji ko abin da doka ta ce ka biya don ni wata ina mamakin yadda za a ce wani wai an ce wani ya zauna cikin wai in ka zo nema sai ya ce maka sai ka biya da kaza sannan yan baka kwanu sai dai kai insisting da abin ka doka ta ce ya ce ya
babu wasu mutane da yanzu waɗanda aka keɓe ga wannan wuri
wa keɓe su
abin da ke cewa babu wasu specific mutane waɗanda su aka yi shaunin da responsibility na yin wannan abin da muke roƙo shine ko wata kotu ku sanya waɗanda aikin su ne waɗannan
ku ba ka ji
Wannan ba ko ta mana kai apply for record ba.
Gaskiya in practice ba haka akai ba.
Ba haka kuka
ba haka akai ba. Kusan shekara goma ina practice ba haka akai ba.
Kai nisa ba ka da abin da doka ta ce. I believe lawyers and litigants are contributing a lot. You will find a situation whereby a lawyer will go to court. Of course, he's looking for something. He will now call somebody aside. Go and do this for me. I'll give you so money. Or a litigant will now go and call the court clerk, the registrar, and so on. I will give you money. Please fix my case. Give me a date that is very close. Don't take my case to so date. And litigants and the lawyers are the ones contributing this. But if we adhere strictly to the provisions of the law, I have filed my case. You take your case to the litigation department. They will tell you the fees to pay. You paid your fees. If after paying your fees, you observe that they are causing delay in sending your file to the appropriate authority, you can make a complaint. Me, I have never, in my own case, I have never received a complaint from any lawyer that litigation department is keeping his file, is not sending the file to the office of the chief registrar to forward it to the office of the chief judge for assignment of the case. I have never received that complaint. And if I receive a complaint in that respect, definitely I will take action against any of the officers of the company.
Bayanin da yake yi shine neman kofin shari'a ko kuma wani ruling. To magana gaskiya abin da kuɗi haka ne wallahi. Ba mai rubuta ma shi kyauta wallahi. Rus ɗin nan ta sun kai bai wuce ma 500 amma har 10,000 ana ansa wallahi har 10,000. Ya dangana ga yawan kofi din nan. Kuma zai ɗauki dogon lokaci. Idan yana iya tunawa wancan last note da muka yi na kawo ga issue din cewa ya kamata a samu wani mutum mai guda cikin ma'aikatan kotu yanzu da zai dinga rubuta wannan kwafi. Za ka nemi kwafi wallahi sai ya kai muka wata 3 ka samu ba akwai lokaci ko hima har lokacin a kulle wuce. Don haka bayanan an sa kuɗi haka yake wallahi ba su bin dokar da rusu ta ce a biya 500 ko kusa haka kwafi ba su don haka kamata ya a samu wannan tsarin malar ko bangaren shari'a ko yawan ga yake ma'aikacin kotu ne assistant clerks ne kwarai da gaske
kuma with the knowledge of alƙali
kowa ya sani ba ku za ku ce ai ga siyar da yana jina alƙali da shi ma kwarai da gaske wani matsala ce mai nauyi.
Ana bin shi 700 amma an kawo shi ruwa a kike cewa me yasa aka ce ana bin shi bashi ne sai kike cewa to nan gidan yari zai samu kudin da zai biya ku maimakon ku ba shi ƙa'idodi masu tsanani ya je ya samu kudin da ya kawo sai kuka kawo shi gidan yari ina ganin yana cikin shine na farko da kika ba ɗaya to ni ma tun lokacin yana da wannan aƙidar cewa alƙalin shari'a ba su babbage ana amfani da su matsayin abin da na an sarrafa shi cewa wasu mutum bai da kudin biya ya ta gidan yari don in kun duba ma kusan kashi 1/3 wa'anda ke gidan yari na yan bashi ina ganin na yi kusan awa 8 ciki awa 6 da biyu sai da suka bi kesin kowa in bayan da bandits wannan duba su ba amma wa'innan mun duba su an dace insha Allah ina jirin da ranka mai shi magana da Allah su babban ana amfani da su wurin mutum ya zo yana bin ka bashi ana zuwa a cikin kamin shi gidan yari kamar kai gidan yari yana cikin a cikin mutum na ƙarshe ishu na time wanda ma na sa shi cewa in na baka aiki zan ce maka let me have your response within 2 hours don ni da kai haka nan mutum ba mu bari abu ya wuce 24 hours sannan kuma magana da kika yi ta abin nan ta cewa in an kawo miki complaint kina investigating, na tabbata da haka. Ba zan ga miki ko ina na gani ba, amma na ga wani da kika rubuta let me have your response within 7 days. Wanda na tabbata da haka. Sannan kuma jama'a ku sani cewa nan wurin da muke nan sama da nan gaba duka mutane ne da muka aiki da su tun da sun ba mu horo mun je mun dawo musu da sakamako sun san cewa sun yi aikin bare saboda haka da Allah ina roƙon kuma ku yi kokari kada ku ba su kunta. Thank you.
Criminal breach of trust ko ce criminal breach of trust in ka duba kuma harkar ciniki ce an kai ko kuma abun nan ne kudi an bashi ya sai wani abu an so abun ya lalace to kuma an kai shi to sai da maimakon a sa a kai shi gidan yari me yasa ba za a tsaya ba a biyo ka'ida a ce to gashi mun baka beli ko so da ka kawo kaza har ya biya don an kai mutum gidan yari me aka yi a cikin mai kuɗi dai ba zaman wancan mutumin gidan yari yake so ba kuɗi shi yake so sannan shi wanda aka kai gidan yari ne will not have the opportunity of looking for that money ya je ya biya kuɗi amma ya ka tsaya haka cewa a'a to mun duba dai abin da harkar bashi ce saboda haka kai ga gashi ka'ida yaushe za ka kawo kuɗin na ai yarjejeniya ya sa hannu in ma har wani zaɓe ya tsaya ya sa hannu ya tsaya zan rika kawo kuɗi daga lokaci a gani in ya saba kuma ina na ce in ma haka din ne a je a mai da shi a yi filin civil matter mana wanda yake ma ya bi kai filin civil matter a je a gama case din nan ya an gama case din nan doka ta ba da dama in ba ka kawo kudin ba in kana da wani property a je a yi attaching a ce suwa a biya wancan kudi to amma ba a amfani da shi sai kawai da mutum ya kawo cewa a muni harkar ciniki ga shi bai kame kuɗi na ba sai a rubuta mai criminal breach of trust a kai shi not only alƙalai na yamma yan sanda ma su ma na musu magana because na ga wasu cases su ma da ake kai on FIR sai a sa criminal breach of trust in ka karanta kuma za ka ga cewa ita ma harkar ciniki ce na ce musu kuma ba institution ne ba debt collecting institution ne ba abun nan ne na duba masu laifi ko abu amma harkar ciniki kun mai da ita criminal matter to su ma cikin su akwai mutanen da na san na saka akan wannan harkar da ne ce su je su file civil matter whoever has anything to claim against wannan mutum da aka so ina roƙon alƙalai still in aka ga muku irin waɗannan mutane ku duba facts of the case ku duba doka ku gani in kun ga cewa is purely civil matter okay mutum ya je ya fara civil matter a mashi case raga da ku kai mutum gidan yari a ajiye shi wata da watanni akwai da na gani ma ya shekara kuna nan aje kuma wai kudin aka da a samu ba a samu kudin ba still mutum yana nan gidan yari so you should please take note of that sir. Say anybody on this issue of indiscipline? Yes.
akan kowanne daga cikin issues guda uku da ke ga agenda kuma tsarin da muka zo da shi cikin yadda Allah abubuwan da aka tattauna da decision da aka dauka kan shi insha Allah za mu yi itemizing nasu mu gabatar da su ga Chairman Judicial Service Commission domin na farko ko dai daukar mataki akan abun da aka ce matsala da mataki ko kuma tattauna su a meeting na JSC ko kuma ƙara jan hankali ga waɗanda haƙƙin jan hankali yake a kansu wannan abun in muka yi haka shi zai sa amfani irin wannan zaman ya fita ga fili ba mu zo mu taru mu zauna mu gama tattauna amma ba abun da ya biyo bayan tattaunawa insha Allah daga wannan zamu fara haka abu na biyu ɗaya daga cikin abin da aka tuna wanda babu wanda aka ɗauka akan shi issue na jurisdiction kamar issue na land aka taba da misalai a kansa wato duk lauyoyi guda biyu suka gabata gaban mai shari'a ko a boko ko a addini kowanne daga cikinsu ya zo da mindset da buƙatar ya ci nasara akan abin da ya zo da shi da haka wajibi ne ya zo da hujjojin shi gabatarwa ga wanda ke da shari'a misali wannan abin da ake tunani shari'a musulunci suna da hurumi na land ko ba su da hurumi duk lauyan da ya bayyana a gaban wani alƙali na shari'a da tunanin cewa suna da hurumi akan abin da suka ya gabatar gaban su ko na land ne zai zo da hujja kuma wanda ke ganin bai da hurumi shi ma zai zo da hujja wani abu da ke da muhimmanci duk da shi inda alƙali zai ɗauka ɗayan biyu ne ko daidai ko ba daidai ba
a lokacin da ya yi daidai shi aka cewa ya cancanci yabo, inda bai yi daidai ba kuma akwai abin da doka ta tanada ba ta hanyar cin mutunci ko ta hanya wadda ba ita ba shine ta ɗauka wannan hukuncin zuwa inda ya kamata. Amma abin da aka tattauna yau akan abin da shafi hurumi ya jaddada ya ma tilasta buƙatar da ke akwai kamar da barista Junaidu ya bayani daga farko yin training akan menene ma hurumin kansa musamman akan abin da ya shafi land da aka ce akan ba su da hurumi. Yanoshi ina ganin wannan zai karfafa wurin buƙatar da ke akwai ta yin training na musamman akan hurumi kansa wanda zai taimaka inda za a yi adireshin wannan matsalar taladin domin shi zai sa taruwa irin wannan idan muka dawo za mu dawo da bayani mai kyau cewa akan ishu na land ga boundary yawa ga boundary mun cimma matsaya based on abin da ya gabata na hukuncin kotocin sama cewa iya abin da shari'a ke iya yi akan abin shahilan gashi wanda ba su iya yi kuma gashi don kowannensu da mu lauyoyi muna da tamu fahimta akan abin da ya kamata ya kasance amma ya gayyato masana musamman su suka bada verdict na court to the hearing of all of us akan cewa this is the position of the law to zai taimaka mu na gaya wurin daukar abin da ya kamata a dauka na hukunci wanda yayi akasin haka bancin yana da masaniya to magana saurayi ta shigo kuma abin da ya kamata a dauka na fannin doka ba laifi ne idan aka dauka. Assalamu alaikum warahmatullahi.
Guys, let's put it that way. I want to extend our profound gratitude to all of you for finding it worthy to grace this occasion for the purpose of having a mutual understanding for the betterment of the legal profession in the first state. Without much ado, we want to appreciate you and wish each and every one of you a safe return back to your various destinations. Inshallah. Thank you.
Sunana Sanusi Gusau, abinda nake so in